45 CR 947 is called the state of Texas versus Jeremy.
We're in a Texas courtroom where past mistakes are stacking up fast, and patience is clearly wearing thin. This hearing involves repeated evading arrest charges, enhanced allegations, and a judge who isn't interested in excuses anymore. What starts as a routine arraignment quickly turns into a blunt reality check about accountability, remorse, and what happens when someone keeps running from the law. Literally. Stay with us, because what you're about to hear isn't just legal procedure. It's a warning about how fast misdemeanor cases can spiral into serious prison time.
Or irrelevant in this hearing.
Correct.
All right. In summary, paragraph 1 of this indictment alleges that on or about June 25th of this year, 2025, in Jefferson County, Texas, you intentionally fled from a person you knew was a peace officer who was attempting to lawfully arrest and detain you, evading arrest or detention. Paragraph 2 goes on to allege that you have 3 prior convictions, 2 in October. Well, so the first one, there's 3 differences. 1, October 29, 2004, out of this criminal district court of Jefferson County, you were convicted of evading arrest and detention with the use of a vehicle. January 4th, 2010, in County Court of Law 3 of Jefferson County, Texas, you were convicted of evading detention. And October 26, 2023, County Court of Law 3 of Jefferson County, Texas, you were convicted of the offense of evading arrest or detention. What is it about that you have a problem with?
This is where the case takes a sharp turn. The judge isn't just reacting to one incident, he's looking at a pattern. 3 prior convictions for evading arrest, spread across nearly 2 decades, now followed by a 4th allegation. In Texas, repeat offenses don't just add time, they enhance the charge itself, increasing the punishment range. When the defendant openly admits he doesn't like police or the law, that's not defiance, that's fuel for harsher consequences. Here's the question for you: when does the system stop giving chances and start drawing a hard line?
You heard what he's saying. Why are we doing this? He's got these other prior convictions. What would that mean?
State jail.
The state jail is the most he can get out of all of this?
Yep. Out of all this, he could probably, he's got 2 prior state jails, so he could probably make it a 3rd degree. But this what goes off. On this Casper.
The 36, that's up to 10 years. It could be. Well, let's do that. Let's let our jury decide. He didn't care. He's flippant on. He didn't care. He didn't like police, doesn't like follow the law. And why? I mean, first of all, somebody's supposed to show remorse and doesn't show it at all, doesn't care. And let's let the law work its way through. Okay. So set it for trial. That is all. Tom, you ready? On something?
This moment is critical. Instead of resolving this quietly, the judge makes a strategic call. Let a jury hear it. Why does that matter? Because juries don't just evaluate facts. They evaluate attitude, credibility, and remorse. The judge openly notes the defendant's lack of concern and refusal to take responsibility, and that matters when deciding punishment ranges. A jury trial also opens the door to higher exposure, especially with enhancement paragraphs in play. Would you take this gamble if you were facing up to a 3rd-degree felony?
This was filed on September 18th, and so it's going on 3 months, and we need to move this thing one way or the other. You are sentenced to 10 years imprisonment, probated for 10 years for unlawful possession of a firearm by a felon, and It is alleged you committed the offense of assault on a public servant on or about August 9th, 2025 in Hardin County. Committed the offense of resisting arrest or search on or about August 9th, 2025 in Hardin County. Committed the offense of assault causing bodily injury, family violence on or about August 9th, 2025 in Hardin County. It must be out of the same episode. And then failed to pay court assessed fees, and you owe $400 in arrears in violation of a condition of your probation. You were sentenced to 10 years in prison, and that was probated for 10 years. Go ahead.
Judge, we're asking that the court grant her a reasonable bond, so that she can go take care of the Hardin County cases. All the state's motion is based primarily on 3 cases, allegations out of Hardin County that I'm unable to affect in any way.
Why?
Because I don't represent them. And so it's going to be, I'm dependent upon what Hardin County does. What I don't have.
No, you're not. You've got to earn a motion to revoke probation, and it's got its own circumstances here, and it's a preponderance of the evidence standard. So it's kind of a different thing. But we don't have to wait on Hardin County, and I'm not going to. I've done this long enough. We move
That's fine.
in an expedient fashion that I think is the appropriate way, and I can't. The other 254 counties I can't deal with, and some of them don't. A lot of them don't move on our speed, and we're not going to wait. She's on this court's probation. In this court, it's this court's domain, and we'll when can we have a hearing on it?
It's a new offense. Hardin County is close, so we can do it in a couple of weeks, Judge.
Okay, well, that's Christmas in 2 weeks.
Yes, sir. Well,
But why don't we set this then first weekend January for a hearing?
yes, sir.
We can go ahead. What else?
That's it, Judge. I was just saying because I would judicial efficiency and try to see whatever Hardin
It's
County.
judicially efficient for me. That's what's important for Jefferson County and the people I speak with, and I know how other counties are. And we dispose of most cases of anyone in Region 2. We all know that. Everybody works hard, and they're all chasing us. So we're going to continue to lead the pack on dispositions and hard work and moving these cases. So it's in our domain, and she's on regular probation right now. So that is the court's looking at these new offenses, and which are serious, and the court is going to, in all due respect, deny a bond, which I can do since she's on regular probation, but I promise this will be done in 4 weeks, one way or the other. Y'all decide if y'all can do it by agreement. If not, I'll make the decision. And the state can be ready in 4 weeks. Thank you. That's what we'll do. Thank you.
This hearing ends with a firm message. Probation is not a shield. When new offenses pile up, especially violent or law enforcement-related ones, courts can move quickly, deny bond, and pull probation back entirely. The judge makes it clear this case won't be delayed for other counties, emphasizing efficiency, accountability, and public safety. Within weeks, a final decision will be made, one way or another.